Good morning, everyone.
Morning, Your Honor.
Morning, Your Honor.
All right, this is cause number 2023-015, Jason Lockridge versus Donnie Lee Pannell and Kenneth Gale Watson on the motion for leave to conduct limited discovery. To move it, make everybody ready to proceed.
Yes, Your Honor.
I'm ready, Your Honor.
All right. And I'll note that this is being held over YouTube in order to comply with open courts doctrine. Movement may proceed.
Good morning, Your Honor. As you just stated, we're here on defendant's motion for leave to conduct limited discovery. As you know, our office substituted for counsel on behalf of the defendants in May 2024. At that time, trial was set for August 2024. And prior to this trial date, we were made aware that Mr. Young had the intentions to assert a counterclaim on behalf of defendant Pannell. That claim was later filed in June and responded to in July. On the date of trial, Your Honor, which was in August 2027, all parties did appear with their counsel of record, and I believe a discussion was had in your chambers explaining the lack of discovery that had been done, specifically that no depositions other than the troopers had taken place. I believe, Your Honor, that the reason for this was explained to you that the previous defendant's attorney, Mr. Howard, unfortunately was having declining health issues at that time prior to our substitution. Due to this, the court ended up granting a continuance of the trial setting to allow additional discovery to take place in this case. Following that trial date, Your Honor, the parties began to schedule the depositions. Our office noticed the plaintiff's deposition, which was later quashed. And likewise, though, the plaintiff's counsel noticed our client, Mr. Pannell's deposition. Specifically, this deposition was noticed this past Friday on September 27th. Our office confirmed this deposition the date before. We ended up actually preparing our client along with our co-counsel, Mr. Young, via Zoom. Mr. Pannell actually did drive to Mr. Young's office that Friday morning to be presented for his deposition. But unfortunately, 15 minutes prior to the deposition, plaintiff's counsel withdrew their notice. And Your Honor, we definitely acknowledge that the plaintiff's counsel did preserve his objection to any additional discovery on that trial date that was previously held. And that is why we have filed our motion for leave based on the good cause which I believe was partially already explained, that due to the previous attorney, Mr. Howard's declining health and the assertion and response of the counterclaim that were filed a month prior to trial, there was simply just not enough time for the depositions of the parties to get done prior to that August trial date. For those reasons, Your Honor, we are respectfully requesting the court grant our motion to allow this limited discovery. We've definitely set it out. So the only thing we are requesting, Your Honor, is the deposition of the plaintiff. Following that deposition, secondly, we're requesting to be allowed to issue subpoenas to obtain plaintiff's prior medical records for any similar injuries. And lastly, Your Honor, we're requesting to serve on plaintiff some discovery requests, which only include 5 interrogatories and 5 requests for production. And we are just respectfully asking the court to grant our motion for leave.
Mr. Atkinson.
I need to go back and start. You granted a default judgment in this case on April 6th of 2023, and you set a hearing on damages for April 14th of 2023. Mr. Watson, not Mr. Pannell, showed up and advised the court that he had hired Marty Young as a lawyer. So we canceled the damage hearing. 2 months went by. There's not so much as an answer file on behalf of any of the defendants. 2 solid months go by. No answer file. So the court then set a July 16, 2023 damage hearing again. after the defendant showed up in court, told you he had hired Marty Young. 2 months went by without a piece of paper being filed. You reset the damage hearing back in 2023. Nobody showed up again. You entered the judgment. Brent Howard called me, and I agreed like an idiot to set aside the default that had been defaulted twice, not once, twice. You set a trial setting and gave everybody notice so that everybody had plenty of time to get done what they want to do now. And they did absolutely nothing. Not a thing. And then show up at the trial setting and beg you into continuing the case. And in chambers, what was said was so that medical records affidavits could be filed. And you agreed to that. And now we want to reopen discovery. Well, here's the problem. You reopen discovery for them, then I've got to see what comes up, and then I've got to conduct discovery. There's absolutely no point. There's absolutely no good cause shown for this. Yeah, Brent was sick when he was hired. That substitution was a long time ago. They did absolutely zero, nothing. You need to deny this. The trooper's been deposed. He was deposed back when Brent was in it. It's time to quit giving over to the defendants because they just want to sit around and do nothing.
Mr. Young, you're muted.
If I may respond, Your Honor, I don't represent Kenneth Watson, okay? So I've never received any notice of any of this. I represent Donnie Pannell. That's who I represent. He's my plaintiff. So as far as me getting notice and Mr. Watson running down to the courthouse saying I represent him is not the truth. I have not filed a lawsuit to intervene in this case on behalf of Kenneth Watson. The statute limited, this accident happened on 10/13 of 2022. The statute of limitation has not even ran on this case officially yet. Okay? I got noticed because Kelly Crain is the one who actually called me and said, Marty, did you know a lawsuit has been filed on this? When he got involved in it in May, just like Miss Olivia said, he goes, do you know that a lawsuit has been filed on this? I said, no, I did not. So I immediately filed my petition, my counterclaim on June the 12th, 2024. Within a couple of weeks of me becoming aware that a lawsuit had already been filed to preserve my client's right to a trial. So I can't help it that I never received notice that a lawsuit had already been filed. There's no way for me to have even known a lawsuit was filed. So once I became aware a lawsuit was filed, I filed my counterclaim. Yes, there's some discovery I need to do. I would like to take Mr. Lockridge's deposition. They can take Mr. Pannell's deposition. I guess Kelly Crane's office represents Pannell and Watson on the defense side, and I've got to get my medical affidavits proven up. I'm not trying to delay anything, Judge. I've just got a right to do this once I became aware, and that's what I'm trying to do.
Well, if I can respond, Mr. Pannell's been a party of this litigation too, and if he was, I don't care who hired him, one of these two people hiring him, if it's Pannell, Pannell's been a part of this litigation the whole time too. That ain't my fault that he don't know or says he doesn't know.
Ms. Levis.
Your Honor, I guess my only response to that would be, I respectfully acknowledge that plaintiff, preserved their objection, but however, I do still believe we have good cause just because we only substituted in May with the trial setting in August. And we have actively tried to get things going since, like I stated before prior to this hearing, we have actively tried to notice the plaintiff's deposition in September. The plaintiff's counsel noticed our client's deposition for Friday. We are actively trying to get this going, and we're doing everything in our power to do so. And we are only asking for very limited discovery, Your Honor, and we have set it out the deposition of the plaintiff, 5 interrogatories, 5 requests for production, and just to be allowed to issue just a couple of subpoenas following that deposition.
Judge, if they entered in May, why wasn't the interrogatory sent before now? Why wasn't deposition notice sent before that now?
I can respond to that and say our understanding is that we were waiting for the counterclaim to be asserted, which it was, and it was the end of May. Mr. Young filed his counterclaim just, I believe, like a week or two right after we've substituted.
The counterclaim was filed June the 12th, 2024, Judge. And if you remember, I think we had court in your courtroom either in July or August with the trial to get it removed.
All right. All right, I'm gonna deny the request. When is this case set for trial? Let me ask that first. When is this case set for trial?
I believe it's set for December 2nd, Your Honor.
November 22nd, Judge.
November, I'm being advised it's set for November 22nd. Pre-trial is November 22nd, and December the 2nd would be the trial setting.
Course last year trial.
All right. All right, well, based on that, I'll open it up for the very limited matters that are set forth herein, but the trial setting stands.
Right. So
Well, I
just,
do, Judge. Then when something comes up
Well,
discovery and
okay,
I need to
I'll
respond to it.
address that unless plaintiff, I will allow plaintiff the opportunity if needs to respond to that.
And so then I get pushed into a continuance.
Well, if y'all can get it all done before then, we're ready to go.
Ron, I can get it done. So let's go take your guy, Mr. Lockridge's depot, and you can take Mr. Pannell's depot. I don't represent Mr. Watson. You pick a date and I'll be there.
We can get it done, Your Honor. Thank you on our end.
All right, we'll stand